So Ellison mentions in his reading, or in his writing, excuse me, when he is talking about those poor black people who are being evicted from their house, and really kind of when the narrator's light starts shining, as far as being an activist, um, he mentions the Constitutional Dreambook during his rant, and it's not really a thing. It's more of an ideal. So we're going to read about the Great Constitutional Dreambook. In his 1952 novel, Invisible Man, Ralph Ellison depicts the eviction of an elderly black couple from their apartment in Harlem. The couple's meager possessions are strewn on the sidewalk. They are fragments of life stretching back to the era of slavery, emancipation papers, a picture of Abraham Lincoln, a commemorative plate from the St. Louis World's Fair in 1904, a newspaper account of the black leader Marcus Garvey, letters from their grandchildren, cheap furniture. As the couple's being evicted, the Invisible Man's refrain is, "We're a law-abiding people." Police officers had demanded the eviction, it's true, but Ellison was asking how their eviction could be consistent with law. Just because something was commanded by a law, in this case a law enforcement officer, did not make it just. Ellison drew a distinction between law and justice, and in keeping with generations of Americans stretching back to the American Revolution, he thought that something unjust could not be law. Moreover, the couple in this novel had almost nothing from which they could be evicted. All they had was the Great Constitutional Dreambook, and even that they could not read. No book had been published, however, with that title. Ellison was alluding to dream books, which in the late 19th and early 20th centuries were popular in African American culture for dream interpretation. The Great Constitutional Dream Book for Ellison and for African Americans during the years between the end of Reconstruction in 1877 and the beginning of the Civil Rights Movement, around the time of the Supreme Court decision in Brown v. Board of Education, was an image, an idea. It alluded to the dreams of what the Constitution might be and the life that might exist under it. At its center was the critique that not everything that is law is justice. Ellison elaborates this idea in his posthumously published novel Juneteenth. In notes at the end of the volume, Ellison discusses the distinction between truth and law. Law put African Americans in subordinate positions, but the truth was different. While it looks like we are what the law says we are, don't forget that we've been put in this position by force, by power of numbers, and the readiness of those numbers to use brutality to keep us within the law. But the truth is something else. We're not what the law, yes, and custom says we are. And to protect our truth, we have to protect ourselves from the definitions of the law. A constellation of ideas then in circulation in the black press on how the legal world ought to be construed constituted that dream book. Ellison was referring to the dreams of African American intellectuals generally, about equality, the campaign to stop lynching, equal funding for separate schools, an end to discrimination in housing, the right to vote, and segregation in public transportation. Those dreams became a movement to place the idea of equality at the center of U.S. constitutional law. As a 1923 editorial from the Oklahoma City Black Dispatch puts it, all the Negro wants is to catch the vision. Moreover, there was a way to a richer principle of equal treatment. While chaos and confusion reigns, the black man can stand and point the unerring way to justice. First, accept the Negro as a man, and in doing this, tear from the statute books all the hypocritical laws that lower his status and citizenship. Acknowledge to the truth that there's no class legislation, that its intent or purpose or in its administration that gives equality of opportunity. If the higher classes of the white South continue in their attitude of lynching the Negro of his rights, they have no just cause to complain when the lower classes of their own life lynch the black man of his life. There's no halfway ground, and the road to justice is plain. The idea of equality, driven by the clear inequalities of American society, gained much strength in the black community in the 1920s and 1930s. Langston Hughes captured those sentiments in his writing, including his 1938 poem, Let America Be America Again, on the divergence between the dream of America and its grim reality. In language reminiscent of Ralph Ellison and others who sought a new order, Hughes asked for equality. What is particularly surprising, given the multiple ways that law abandoned African Americans, through absurdly biased criminal prosecution, lack of protection from violence, laws that disenfranchise voters, school and housing segregation ordinances, and reinterpretation of the Reconstruction Amendments in ways that dramatically limited their effectiveness, is the resilience of African Americans' faith in law. Cases from the Jim Crow era, such as Plessy v. Ferguson, Cumming v. Richmond County Board of Election, Brea College v. Kentucky, and Gong Lum v. Rice, illustrate the difficulties racial minorities faced in obtaining even minimal justice. Other cases in which the U.S. Supreme Court struck down unequal treatment, such as grandfather voting clauses in Gwynn v. United States, racial zoning legislation in Buchanan v. Worley, and peonage in Bailey v. Alabama, or overturned convictions obtained in the wake of race hatred, Moore v. Dempsey, and police brutality, Hollins v. Oklahoma, further illustrate the legal system's gross unfairness to African Americans. Many African Americans, of course, had little faith in the legal system. Young Ralph Ellison was one of them. He told of a quip an Oklahoma judge made from the bench. The Model T Ford full of Negroes ranging at large on the streets of the city was a more devastating piece of bad luck than having one's path crossed by 13 howling jet-black cats. Given such statements, the law, as established by whites, could have little legitimacy in the black community. As a result, it was jazz musicians, those representatives of counter-society whom the young Ralph Ellison idolized. Like the Louis Armstrong song, right? Among some in the white community, the law had little respect as well. Watch John Steinbeck depicted in The Grapes of Wrath, his 1939 novel about the Joad family. When Grandpa Joad dies on the way to California, his family worries that the law would not permit them to bury him. If they could not, perhaps they should become lawbreakers. Sometimes the law can't be followed no way, said Paul, not in decency anyways. There's lots of times you can't. Sometimes a fella gotta sift the law. I'm saying now I got the right to bury my own pa. The preacher rose high on his elbow. Law changes, he said, but gots to's go on. You got the right to do what you gotta do. Still, some had faith in law, and it is those people who created the great constitutional dream book. How could they have such faith? In part, their experiences during Reconstruction, when for a brief period a different conception of the world appeared, sustained them through the dark years of Jim Crow. In part, perhaps, there was no place else besides the law where people could look for hope. One often overlooked aspect of African Americans' religious beliefs in the late 19th century was the view that the Promised Land would yet come. That optimism among such people such as Roscoe Dungy, the editor of the Oklahoma City Black Dispatch and a father figure to Ellison in his youth, appeared in the pages of his newspaper and in his demand that the world be ordered differently. Even though members of the Oklahoma black community impugned Dungy's masculinity for his suggestion that the rule of law might offer some hope, Dungy made constant appeals to law through both his newspaper and his community service. In the 1930s, he served on the board of the National Association for the Advancement of Colored People, and in the 1940s, he pushed Ada Lewis Sipule to file a lawsuit to integrate the University of Oklahoma's law school, Sipule versus the Board of Regents. Earlier in the century, the dreams of African American intellectuals had influenced the development of political action and litigation strategies. What must have been particularly sweet for Roscoe Dungy was that even though his idea of faith in the Constitution was ridiculed, he lived long enough to see the 1954 Brown decision. In the aftermath of such criminal breakdowns of the rule of law as the 1921 Tulsa riot, Ellison noted in Going to the Territory, a 1979 lecture he gave at Brown University, that Brown would have been an unthinkable, even a comic practical joke. Later, as a professor of literature at New York University, Ellison praised the virtues of Dungy's faith in the principles of equality in the Constitution. That faith in the Constitution was repaid. What remains ambiguous, however, is whether faith in the Constitution is what led to the Civil Rights Movement. One can identify the content of the Dream Book, but there is still the important question of what was the relationship between the Dream Book and the Civil Rights Movement, and such cases as Brown. In some very basic ways, there are connections between the authors of and the ideas in the Dream Book and the Civil Rights Movement. For instance, the NAACP was responsible for instigating litigation that led to the movement, from the case striking down the grandfather clause, Gwynne, and the racial zoning ordinance, Buchanan. Particularly under Charles Hamilton Houston's leadership, the NAACP's litigation drove the cases, establishing that separate treatment had to be equal, ranging from Missouri ex rel Gaines and Marvin versus Oklahoma State Regents to Sweat versus Painter, and even parallel cases on employment, such as Steele versus Louisville and Nashville Railroad, and on voting rights, such as Nixon versus Herndon, which led directly to Brown and, of course, Brown itself. What's harder to establish because it deals with showing causality in an area in which no causation is difficult to show and where many different factors combine in the outcome, is the role of the Dream Book in establishing equality as a central constitutional value. There's no question that the meaning of equal treatment changed over time. For instance, Justice Oliver Wendell Holmes' dismissive statement in 1927 on equal protection as the usual last resort of constitutional arguments stands in contrast to Chief Justice Earl Warren's 1954 statement in Brown about the importance of equal protection. Warren looked to the context of public education, its present place in American life, to conclude that separate educational facilities are inherently unequal. Many factors contributed to the remaking of the matrix of constitutional arguments from the 1920s to 1954. During World War II, there was a rhetorical attack on Nazism, when it became difficult to maintain segregation in the United States against complaints about Nazi racial purification. There was the Cold War campaign against communism, when the United States sought to win the hearts and minds of people of color across the globe, and the country could ill afford to be seen to giving unequal treatment to some of its citizens. For the scholar Derek Bell, there was an interest convergence between African Americans' desire for equal treatment and the majority's need to appear equal. Although it's undoubtedly helpful to have the political interests of the majority on one side in a constitutional argument, the move to expand the Supreme Court's equal protection jurisprudence antedated U.S. involvement in the Cold War and even World War II. Moreover, some Supreme Court decisions from the darkest days of the Jim Crow era, including Gwynne and Buchanan, were inconsistent with a pure interest-convergent model. Thus, at least some of the progress on civil rights within the courts appears to have resulted from the justices' understanding of the 14th and 15th Amendments' guarantees of constitutional rights. To construct a multiple regression equation for significant factors in the Supreme Court civil rights doctrine, one must account for litigation strategy, court precedents, justices' understanding of history, and consideration of economics, politics, and morality. Constant editorials in the black press pointing out unequal treatment also may have spurred the legal system to take claims of inequality more seriously, to acknowledge that the unequal treatment was, indeed, not justice, not law, and to take corrective action. The great constitutional dream book existed in the minds of many. How many white judges read it and then acted on it is something being debated still. It's kind of an interesting article then about the great constitutional dream book and the legal battles of the time and the time soon after. So the great constitutional dream book was not a book, but it was an idea. And it alluded to the dreams of what the Constitution might be and the life that might exist under it. So I can't really get that to highlight. So that's what the Great Constitutional Dream Book is, and what was thrown out for those people that Ellison wrote about during that time of eviction. And so the fact that it was thrown out, cast aside by these white police officers, is really Ellison saying that, this dream that they may have had of being equal under the law and constitutionally speaking was tossed aside. So thanks so much for listening. Have a great day. Let's see if I can find the thing to turn this on. Sorry.